My lord, when the offence was registered, section 74, not less than 1 year may extend to 5 years. 75 BNS may extend to 3 years. Section 12 POXO, my lord, may extend to 3 years. Offence, my lord, that comes to be added subsequently. My lord, no, this is where, my lord, I have a gripe. My grievance is, unlike a regular case, my lord, where post-assault, my lord, complaint is filed the next day or the next day thereafter. And my lord, in a section 161 statement, and I said, my lord, there's a slight latitude only in sexual offence cases. Every other case, there is zero latitude. Court will do it with great suspicion. But even if your ladyship want to give certain latitude to them, if such a complaint is filed, my lord, after so much of deliberation, contemplation, and legal advice, referring to Supreme Court judgments, referring to consent being immaterial, referring to, my lord, the aspect that if you have taken consent under some deception, it is wrongful, but they would not miss out an important detail of penetrative sexual assault. No offence under that particular section is made out. So yesterday, my lord, I had made this argument for your ladyship's consideration. It can sometimes so happen that the complaint may attract a particular offence. But police, my lord, because they are not so well, because when they deal, my lord, no disrespect, my lord, they may have missed out adding a particular offence. But if your ladyships are going to be satisfied that from the complaint there is absolutely no allegation of penetrative sexual assault, and if the offences that are made are correctly recognized to be these offences which are all punishable under 7 years, I would have been straight away entitled to the benefit of Arnesh Kumar. My lord, I would have participated, I have assisted in the investigation, my lord, and the matters could have gone, my lord, in the way the law contemplates. Now, what they do is after they file this FIR, maybe if they thought, my lord, the notice of the FIR being given in the media would scare me and I would come around for, my lord, a settlement or whatever. If that did not happen, then they go and give a further statement. So the further statement given thereafter, my lord, in my respectful submission, is something that today.
Is the further statement voluntarily given or is it during the course of
161
statement?
161 statement. My lord, these improvements that are made in 161 statement, I'll place, my lord, 2 or 3 judgments for your ladyship's kind consideration. The court may view it with a great deal of suspicion. My lord, I'm putting it at the highest. I'm not saying they should be discarded. At trial, my lord, what is the veracity to be given, your ladyship may consider. But if, my lord, the law in POXO is not prohibiting the grant of an anticipatory bail, now this is something that will come into, my lord, the court's parameters of consideration, that if the original offence which you are filing after 4.5 months is not alleging any penetrative sexual assault, and if this is only providing for punishments below 7 years, can it be thought for a minute that the subsequent improvement, because by then you're already completely informed legally, a subsequent improvement, my lord, if it evokes any suspicion in your ladyship's mind, my lord, that I would respectfully pray, my lord, ladyship may have to grant me the benefit of doubt that there may be a possibility of an improvement for the limited purpose of an anticipatory bail today. My lord, not because otherwise what it does is, it now straight away takes the category of offences from punishable below 5 years to 20 years or remainder of the remaining person's life. My lord, please see the jump. There is a huge jump in terms of gravity that happens by way of an improvement. So that one improvement that is being done, why was this not mentioned on the day before? Especially if they have been contemplating legal steps from the month of March, especially if they are already aware of, my lord, various legal nuances in relation to a POXO case. If they are so well aware, my lord, they would not have missed out this most important detail, and that in my respectful submission throws any amount of doubt, my lord, on their deliberate attempt to frame me in such a way that I cannot but be arrested, my lord, in this particular matter. So this may amount to, in my respectful submission, an abuse of process of law, and, my lord, trying to use the process of criminal justice for a purpose which is not intended. My lord, I am taking guidance, my lord, from your, my lord, several judgments that your ladyship, my lord, this honorable court and the Supreme Court has laid down in relation to SC/ST Act. SC/ST Act, there is a textual bar on grant of anticipatory bail. But, my lord, the courts have said, look, if you are trying to ensure a person is coming under SC/ST Act for the purpose of preventing him to take an anticipatory bail, the court will look behind the complaint to see whether these incidents actually constitute that or not. My lord, I am requesting your ladyship to give me that additional leeway into the court looking into only this additional section. But I'm not arguing that the court needs to give me for the entire POXO Act. But if the complaint given at page 16 is taken, I will concede section 11 and 12 of the POXO Act are made out. But the improvement that is made, but in fact, if this improvement constituted a basis of the original complaint also, but I'm putting it slightly higher, my lord. Even if this improvement was a part of the original complaint, like in SC/ST Act, it's a part of the original complaint. If the court contemporaneous material, if the surrounding material excites a doubt in the mind of the court that this seems to be a contrivance for bringing it under SC/ST Act, the court says, no, we will disregard this because at this point, we will grant an anticipatory bail. So, my lord, today my respectful submission is, even if the improvement was originally a part of the complaint, if the contemporaneous, my lord, material at that particular point of time was going to raise a doubt in your ladyship's mind that this assault that they are talking is not correct, because the messages before and after, nothing is speaking about it. Even after, my lord, 6th January, nothing is speaking about it. Unless, my lord, the learned public prosecutor appearing for the police can place something else that I don't have access to right now. So, my lord, if I may now, therefore, my lord, make my point that the original complaint, all the offences correctly categorized. The improvement in what manner, I am not aware, but improvement is happening later after they have been legally counseled. So, the court may have to discard it for the purpose of interim bail. But there's a judgment, my lord, that I'll be placing very quickly. My lord, the court, while granting an anticipatory bail, tells us, my lord, when we are reading that judgment, my lord, when I say us is our lawyer community, this is not allowing someone to go scot-free. Anticipatory bail, my lord, is not like a quash. Your ladyships are not quashing the complaint. My lord, if your ladyships are otherwise persuaded by our argument, should your ladyship consider granting an anticipatory bail? Whether that improvement would actually stand up to trial, whether that sections need to be charged at the stage of framing of charges, my lord, all of that, there is a different journey. Unlike a quash, where, my lord, we would pray the court to quash the offence today. So, my lord, today we are not asking for quash, we are asking for a limited benefit to be granted to us in the case of anticipatory bail. My lord, this is my argument in relation to the complaint. What I want to do, my lord, is very quickly, because the ladyships have noted the 4 dates, but I am placing this in a sealed cover and giving it to my friends in a sealed cover. In fact, I must also seek a ladyship's permission. But normally when we file these cases, we redact the names. In relation to some certificates that were filed, when we have to seek your ladyship's permission for redacting.
Yes.
But unfortunately, my lord, what happens is these days, I don't know how, the moment bail petition is filed, luckily, my lord, bail petition was filed without giving the prosecutrix name and the redaction. I'm told, my lord, this bail petition has been circulated in social media with underlying and analysis. Those certificates, my lord, if your ladyship's permit, I'll ask my colleagues to redact it, and the originals, my lord, or whatever certificates we may place in a sealed cover, which your ladyship can ask the registry to keep it in a sealed cover so that, my lord, the victim's name does not come out. So, my lord, this.
I hope they have no objection to that.
My lord, certificates are very expensive. Court record, photocopies, we circulate just on social media. My pair by then nothing.
We are serving documents could be given and that could be used in a bail application. There is no such law. There cannot be, from the prosecution side, only the documents have to be looked into. Any document at this stage filed by the other side are actually not, they are not to be looked into.
No. What he's saying is, not these are not additional documents. Documents, I think.
Correct. Already
along
filed.
with the bail. No, what I understood. Let him
correct.
if I'm
Ladyship's
also
are
the
In case if he is taken into
The
custody
documents
or-
which are filed along with the bail petition, there are certain places where the names or name of the prosecutor have not been masked.
Strike.
They have done
It
it
is not
purposely.
masked.
They are liable for
So
prosecution
now,
for that, my lord.
that
Now
is-
at this stage, the court cannot accept those.
So he
They
wants
have
to
come out
now
clearly,
mask
my lord.
it
The
and give
passport-
other documents.
Well,
What I respectfully submit is the passport, her photograph is published, her names are published, the certificates, birth certificates, her names are published, and now they cannot then say that I want to take it back. And now if we accept that, it amounts to, letting them go scot-free of the offences what they have committed.
So if they
It is
have-
they are punishable by 6 months.
Let him argue,
Let
my
the
lord,
prosecution take its own course. We are not willing to take that.
In respect of the date of birth certificate, other certificate, I collected from the IO, my lord. I may be permitted to
Why
place.
sir, they are collecting my date of birth certificate?
An application is given by the advocate to some other person, some Anthony Reddy and all. They say, we want to inquire. Who are you to inquire about my date of birth and date this thing?
Well,
It does it
I've
not
stayed-
amount
I've
to
stayed on
tampering
legal
with evidence?
My lord, I've stayed on
Register your
legal
objection
arguments.
to this.
Yes, my lord. Now, this is, my lord, the first, because, my lord, the complaint specifically refers to the messages that are being given to the police. And this is where I want to go and assist the police. My lord, your ladyship may kindly see. My lord, what I am placing is the chat between, I'm giving a copy to the learned public prosecutor. So, my lord, your ladyship would notice that whatever I am giving for your ladyship's kind consideration, and I will not read this. Ladyship would notice page 14. Your ladyship will notice the date, my lord, below the letter, just above the letter, 25th October. My ladyship notices, my lord?
Yes.
Above 25th October is the previous chat. But I have not given the entire one, my lord, because I just wanted to focus on the dates that are forming part of the complaint. My lord, very important. Your ladyship sees on the left side above 25th October.
Yes.
My lord, like it happens, my lord, in WhatsApp, left side is what I receive.
Yes.
That is, my lord, this is the victim sending it to me. Right side is what I send. I had indicated yesterday for your ladyship's kind consideration. Left side on the top, there is a suggestion of a place now made by the victim. Because yesterday, my lord, the complaint I read to your ladyship to say that she was taken from place to place, indicating that she had no knowledge and, my lord, she was being taken forcibly. My lord, now please see next page. Is 26th October.
Yes.
This is after, my lord, that incident of 25th October, my lord. 25th October is one incident.
Hmm.
At the bottom left hand side,
Yes.
this is, my lord, movie tickets being sent by the girl because she wants to go for a movie with this boy. Next page also, page 16. This I am placing for ladyship's to consideration to show that if 25th October was the incident as alleged by the mother, my lord, then this does not align with the case of a person who, while being in a relationship, was forced to undergo any sexual harassment. And I am not even using the word penetrative sexual harassment. My lord, then please see next page. This is, my lord, everything that happens. I therefore said they were in a cordial friendship, stroke relationship, my lord, in terms of the complaint prior to one incident.
Hmm.
My lord, ladyship may only notice page number 18, right hand side bottom. But I am not reading this out aloud. There is a quotation sent. My lord, next incident, my lord, if I may just place, is 13th November. Separate copies here. Now, this is a material I must give it to the police, my lord, for the purpose of assisting the police. My client just needs some interim protection so that he can go before the police and place all of this. Your ladyship has the date 12th November. My lord, in the middle of the page, below the
Yes.
photographs.
Yes.
Above that, my lord, are photographs which show that the family and the boy and the girl went to, my lord, some spiritual places together. Just below 12th November, your ladyship may see the time length. My lord, check. Another incident is 13th November, my lords. Page 17 top, your ladyship asked me, where is the date? 13th November. 13th November is the relevant date. Another incident. Now, 12th November, just below 12th November, left side, does my ladyship see
8 hours.
voice call 8 hours? This is call made from the girl's phone originally. It originates from the girl's phone. 13th November, voice call 6 hours. 13th November, they are talking normally for 6 hours. 8 minutes. Next page, your ladyship would see regular messaging, my lord, between people who may be in a relationship or friendship. Next page, 14th November, voice calls exchanged.
Yes.
14th November, my lord, is the third line. And your ladyship says 14th November, voice call 6 hours. Again, voice calls, my lord, then messages are going on. Next page also, your ladyship would see all normal messages. So, my lord, 13th November, nothing for the my lord, court to at this point glean that the incident of 13th November that is referred in the complaint, it may need to be investigated. I am only trying to place, because my lord, the complaint refers to social media chat. I am placing social media chat prior and after between these people, and my lord, this is between the victim and my lord, this particular person, that nothing from this chat indicates something serious. Maybe there is something more. That will be their case. Maybe a case for investigation. I am arguing this for the purpose of interim, my lord, anticipatory bail. My lord, next is 31st December. Copies wala good. Seal cover level number. But in fact, my lord, this 31st December, there are other messages which show that they were planning a 31st December get together with friends for a long time earlier. And my lord, the places were being suggested by all people. We'll go to this place, that place, not that she was forcibly taken as the mother tried to complain. Now, Lord Ladyship sees 30th December.
28th.
30. 30, my lord. Page 5.
Yes.
Which number? Third set. My lady's husband on?
Yes.
My lord, ladyship sees on 30th December, what is forwarded by the boy to the girl is Telangana Excise Department giving permission. But Excise Department, your ladyship knows, the permission is if they want to have a small private party if they are consuming liquor. Now, then please see next page.
Yes.
No, I'm sorry, same page below, 3rd January, your ladyship sees there are missed calls. When she calls, not picked up. We don't know what transpired, what was the fight or whatever. Next page, regular, some forwards of messages on 5th January. Left side, my lord, something that the girl sends, the photographs. Next page, again, 5th January, my lord, photographs of something sold. At the bottom of the page, my lord, again, typically, my lord, in a friendship, because the mother calls it a relationship and I don't know them as well, but I'm only, even if I take the allegation to be true. But please see page 9. I think the problem starts, my lord, after the missed calls start happening from here. 7th January, the mother admits relationship broke off. But 31st December, 1st January, the nature of allegations made, which my lord in the original complaint were at the nature of sexual harassment, lord, nothing of that nature reflected from lord, the contemporaneous surrounding circumstances. And this is a test your ladyship my lord has laid down in the SC/ST case, that even if the complaint were to make, in this case, had the original complaint made an allegation about penetrative sexual assault, which is section my lord 5 and 6. Even then, if there is something for the court to see that this may be something that is just added for the purpose of spicing up the complaint, the court can look behind. Luckily for me, but I have a much lesser burden to discharge, because if I take the allegation entirely, post proper legal advice, post them contemplating legal action from March, filing the complaint in the month of May, 8th May, if they have not made that, that in my respectful submission singularly entitles me to the grant of a limited benefit of doubt for the purpose of anticipatory bail. Your ladyships are not deciding the issue, your ladyships are not discarding the improvement, your ladyships are not saying that no case is made out. As long as the court thinks that this is a matter where if I need to be taken into custody, that is the original sections required me to take into custody, it's a different issue. They did not require me to take into custody. So any improvement made, as I said, my lord, the normal latitude may not be available in this case, because the original complaint is filed, as I use the expression, my lord, with full contemplation, full deliberation, full legal advice, my lord, and your ladyship may see the language, my lord. It would have done me proud. Honestly, my lord, I'm not trying to demean it. It's a very well drafted legal complaint, which clearly emanates, my lord, from some very good legal advice they have taken. So if someone who's so legally well advised uses, my lord, the nature of language which I'm complimenting them, that is not making this allegation, any allegation made thereafter may be incorrect. Lord, lastly, my lord, very quickly now I have to show some law and then I'll conclude, my lord. My lord, your ladyship may kindly have, my lord, POXO Act.